so far. That's issue number one. Issue number two, the defendant had extra amount of time to provide it between September 3rd and now, and the interrogatory's answer have not been provided yet. The issue number three is that 2 days ago, I received from defendant about 513 pages of stuff. And what I want to call stuff, Your Honor, is mixed documents from this case, from the case we have with another judge, district court. So what I call it stuff is just stuff. And I do not know what it is, but if the defendant is planning to use that as answer to the interrogatories, there is an issue of that situation for the fact that the Rule 197.2c does not allow for the burden of receiving interrogatories to be placed on the receiving party. And issue number four, Your Honor, is there's no response. It appears that the defendant is agreeing with the motion that I made. There's no response on file. And for the reasons mentioned above, the plaintiff is requesting for the court to award sanctions and for the court to compel answers to the interrogatories that are still outstanding.
Response?
Yes, Your Honor. We respond to the interrogatories the same way in every single case. We put together a concise report from our expert witness that outlines every single answer, and we refer them to that answer. We've done that in this case. That's what we do in every single case. It's been blessed by courts before. If we need to get more detailed answers, I'm going to need more time because my litigation director, who I've worked with for 14 years, has retired effective on the 1st. So I don't have any, as you know, we withdrew all of our witnesses because she retired. We produced the documents that are responsive. And one of her last things that she did, and I made sure to ask her, did you give him everything that he has asked for? And she said, yes, I did. So he has every single document that's responsive. He has the answers to the interrogatories. We tried to get this case mediated last week and the mediator canceled on us. We just desperately need him to give us an offer so we can get this thing taken care of or get the case over with. We have no witnesses. We have just relying on him to present his case. He's yet to present any evidence to us as to what his case even is. Of course, the burden's on him to prove the case. So,
Mr. Metcalf, did you guys index, for example, when you're responding to request for production number one, did it say which pages are responsive to those and are they bait stamped?
I don't believe so, Your Honor. It was it is 400 pages of documents, but it's 30 pages of printouts for each comparable. We've been dealing with him for the last 5 years. He should know these documents backwards and forwards. The same comparables that we provided him in another case are the exact same comparables for this case. So he has the documents months ago because he has condos and he's asking for information on the comparables, which is all available online. If he just types it in on the system, it's all there for him. But we have produced it to him many times so that he'll stop filing motions to compel on us. I believe this is the 14th or 15th one in the last 2 years. We're doing our best that we can to comply. I don't know exactly what he wants. The total value in this case is under $30,000. So if we can make him happy in any way, shape, or form, we'll do that. We tried to mediate this last week. We all rearranged our family vacations and the mediator canceled on us. So
who was the mediator? Was it through
UCRC?
Okay.
Which they're free, so we want to use them, but we get what we pay for. So we understand we want to get that reordered. If they said that there was an order from the court that canceled it, I don't believe that's accurate. I think it was just conflict on the holiday. So, but Mr. Swansky can speak.
You know, I think we did get something. We didn't cancel it, but
yeah.
Does DRC, do they mediate many of your cases?
We don't hardly mediate anything, Judge. We can just knock these out with a couple emails usually. But we have used them once before with the.
I think they said that your case doesn't qualify because you're represented by counsel. I think So we may have to send you to a different mediator.
Sure. At this point, we'll take anyone.
Okay. I'm trying to think who could be quick on this. Mr. Smolinski.
Yes, Your Honor.
So unfortunately, we've been told that the rules are that you're going to have to go to mediation at some point.
Yeah, that's okay with me. What happened, Your Honor, after the meeting we had on November 8th, I took lead, and on the next day, I arranged with Mr. Metcalf and DCDRC mediation. We were scheduled for 23rd. It was confirmed. We both replied that we are going to be there. As of 22nd, I didn't hear anything. I inquired about the Zoom link, and at that time, I was told by Teresa Valdez that the 68th court with Rhonda canceled it. On the next day, just to make sure we are still canceled, I went to the court at 9 a.m. as we were scheduled, and I spoke with Teresa Valdez. She told me that the coordinator from the DCDRC canceled it. So I don't know which story is true.
Yeah,
I don't know
I think
exactly
what happened. I think that they canceled it because there's certain criteria that they use to accept cases, and you guys don't fit in the criteria. So there's not going to be, I don't know of any other free way to do this. I'm trying to think. We could send you to Irene Zucker. Who do you typically use, Mr. Metcalf?
We use Jay Zaleski or Woodrow Mickey Benicio from used to be at Hall Extol. Jay gives us a fair rate, and so does Mickey, and they're familiar with property tax. Mr. Smolinski has never agreed to them.
No, that's not a correct answer, Mr. Metcalf. We've asked and we talked about mediators, and the only answer I had as far as different mediators was Mr. Frederick Lewis was scheduled at one point, and Mr. Metcalf didn't agree to him. And the second option we have with Judge Tanya Parker, we're gonna be using Richard Pullman, and I offered that, but there was no response to that. So my only concern is that it is reasonable in terms of time and reasonable in terms of fees. So, for example, Mr. Pullman offered agreed to us for the other case to mediate for an hour, because on average it takes us about 30 minutes to an hour to mediate if we do, for $150 for that mediation.
Who would do that? You said for an hour?
Richmond Pullman, he was assigned to us by Judge Tanya Parker, and he would do 1 hour mediation for us for $150.
Mr. Metcalf, what is your views on Mr. Pullman?
I've never used them, but if that seems fair, I'm willing to try anything.
Okay, so what we're going to do, Mr. Metcalf, you need to prepare an order on this. We're going to order this case to mediation with Mr. Pullman. 2 weeks after the mediation takes place, you're going to need to, if it doesn't settle, you're going to need to supplement the discovery responses with the following. You're going to need to bait stamp all of the documents, and then you're going to need to refer within your request for productions. You know, if pages 1 through 57 are responsive to number 1, then you need to say see Bates numbers 1 through 57, so it's clear what's responsive to what, and that will need to happen 2 weeks after the mediation.
We'll get that order to you by tomorrow morning.
Okay.
Your Honor, I do have a concern. As we move through this process, the defendant gets an option to get a lot of extra time. To produce 530 documents versus answering 8 interrogatories does not seem like an intent to answer those interrogatories. And for year 2021, the defendant answered some of those interrogatories. When we do that, the batches, many many times do not include the answers that are being asked. And what happens after that, we wasting time again, coming back because the details are not there. I believe the defendant knows what we're asking for. I don't think he had time to prepare it, and he didn't prepare it. But for him to get allotted, extra time and not answered, that the order for the discovery specifically stated for him to answer, not to provide documents responsive to it. And that's my objection. And he can answer it faster than producing those documents. Also, he was asked to produce those documents long time ago. Those interrogatories long time ago. So time is not of an issue. I think it's the intent whether he wants to answer it or if he wants to continue the restricting, resisting the discovery process. That's how I see it, Your Honor. And if the defendant truly states that all the answers were provided, I have the 5 batches that he sent me right now, and let's read some of the interrogators he didn't answer, and he can tell me where I can find it. And that will prove where he knows where it is or if it's even there, because I do not think it's there. And it's a mixed batch of two different cases. It's not well organized. There was no documents with it. The only thing when I received the emails was sent from my email. That was it. That's not a way to present in a proper manner discovery responses or even an attempt to. Like I said, Your Honor, I have those files here, and if the defendant can tell me where they are, then we're done. If not, then it proves that they're not there, because they're not. Most of them will not be there.
Mr. Metcalf?
I obviously have to rely on my client. And if I ask my client that they've provided everything that's responsive and they say, yes, I have an affirmative email from my client that says that, that's all I can do. I matched them. It's the same thing we produce in every other case. I'll be happy to talk to him after this. If he wants, he can call me on my cell phone and we'll talk about it as long as he wants. I don't think he'll ever be happy with anything I say. I think that he thinks that there are things that exist that do not. I think that he assumes malice when incompetence would explain lots of things. I literally have tried to make him happy for 5 years and I can't get off high center. So anything that he wants, I'm happy to do it. My job is to make sure that he is, I have 3,000 of these cases. It's all I do every single day to try to get them resolved. This is the only one I've never been able to make any progress on. I think he thinks we're hiding something. We're not. We lost an employee that's critical, that we had to withdraw all of our witnesses from this case. He still has to put on some sort of case. I don't know what his evidence is. He's not ever provided me any of that. I don't want to take his deposition because we have more efficient uses of our time. But I just don't know what he wants.
Your Honor, it's we deterring here about what's going to happen in this case and how it's going to happen. If the defendant had questions or wanted to ask questions, he could have requested any discovery he would like. He never presented any discovery, so that might be one of the reasons, the main reason he doesn't have evidence yet. The evidence will be provided to him in a timely manner as is being prepared.
We look forward to seeing it.
Okay. As part of this order, make sure that it also includes that you're going to fully respond to discovery. I understand, Mr. Metcalf, you're very busy, but you do have to, it's your choice to have 3,000 cases. And so I understand that you have somebody who's mucking up your system, but you still have to obey the rules. So
we will do that, and I'll have verified.
As part of the order, it'll need to say that it's that you'll fully respond to discovery within 2 weeks after the mediation, and that you'll bait stamp and categorize the document so that he knows what's responsive to which request.
And we'll provide verified interrogatory responses as well and not refer to documents. Mr. Smolinski, I'll get you a copy of that order tomorrow morning so we can upload it for the court.
Thank you, guys. You guys have a good day.
Your Honor, one more question. I did present
Mr. Lacey, one
order.
second. Whoa, just 1 second. Mr. Lacey, do you still need your hearing today, or are you passing it?
I believe I do. It's just a motion for subservice that we were told we needed a hearing for.
Okay.
So,
Mr. Smolinski, I'm so sorry. I got to get to my next hearing, but I made my
Very
order.
short,
We'll
just a
send
second,
you
Your
some-
Honor. I have a proposed order on file for this discovery issue. And would the court consider using that order and signing it? It's been already on file for about a week. So the form should be okay as far as the local rule. And would the court consider and use the proposed order already made?
Have you looked at the order, Mr. Metcalf?
I don't think so, Your Honor. I will look at it right after this, and if we can use it, I'll let him know tonight.
Sounds good, guys. Thank you.
I understood you ordered us to meet with Mr. Pullman within the next.
As soon as possible.
All right. Thank you, Your Honor.
Thank you, guys. You
Okay,
are
thank you, Your
excused.
Honor. Have a good evening.
All right, Mr. Lacy, let's go through there was an issue with your subservice, so let me pull that up.
thank you, Your Honor.
No problem. All right, I was just looking at this. I think the issue was there was some issues with the way that your process server did his affidavit, but I've looked at it pretty closely now. I think it's okay. So I'm going to sign the order. Let me just double check one thing. It looks like your DWAP is set for December 13th. I doubt you're going to be able to get service and everything done in time by then. So do you want me to move your DWAP hearing?
Yes, Your Honor. Oh, sorry. Yes, Your Honor.
All right, we'll go ahead and move that to mid-January.
Thank you, Your Honor.
All right, this order should be entered. Should hopefully be entered by tomorrow. So you should be able to get it by tomorrow. And I'll let Rhonda know to move the DWAP on this for 30 days. So it should be sometime in anyway, yeah, sometime in mid-January. All right, thank you so